Hi everyone, Sarah Willey here with Off the Clock. Just a reminder that all of our episodes are available streaming on any podcast app. So you do not have to sit at your computer and watch us, and maybe don't want to. You can download any podcast app and search Miller Johnson Off the Clock and access us there. If you're feeling particularly generous, give us a rating and or recommendation as well. Thanks so much. Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. We are your co-hosts, Rebecca Strauss and Sarah Willey, two employment lawyers who spend their days guiding employers through all of the challenges that workplaces offer. Well, hi, Rebecca.
Hi, Sarah.
Here we are on our couch again.
Fancy that. What a coincidence. Do you come here often?
Only for really good legal conversation.
That's true. And let's just say how this whole thing started, right? I'm not going to give the whole origination story, right?
Yeah.
We'll wait for the movie version of the origination story. But when we were talking about the concept, you actually do have a couch in your office. This is not your office, but you do have a couch in your office, and I would come in and talk, right? So when we started talking about the concept of having a podcast and just talking, we started talking about it as sitting on a couch, just talking about legal issues, and that's how we ended up here. Right?
Yes.
On this couch in our conference room.
Here we are, and it's been great because now we have scheduled couch talks, which are awesome. In addition to our unscheduled.
Scheduled fun.
Exactly right.
But that's okay. We lead busy lives, and as we all know, sometimes you do have to schedule in these things if you really want to make them happen.
Right.
So we are recording on a Friday.
Yep.
So I have an idea.
Okay.
Should we do FMLA Friday? You know how fun Taco Tuesday is, Sarah.
Right.
I was thinking,
yes,
FMLA Friday could be just as fun.
I think that's a fantastic idea. And you knew what my answer was going to be.
I did.
FMLA any day. FMLA any day, I think, is a great idea. And FMLA Friday is a great idea. And I particularly think it's a great idea because I have been getting a ton of questions, both from colleagues like you.
Yep, guilty.
And from clients, right, about FMLA again.
Yeah,
and by again, I mean non-COVID related FMLA questions, just regular FMLA questions.
So we're not going to talk about another F word, the FFCRA, right?
Correct. Right. Yes.
Right. That's one that's not FFCRA Friday. It is FMLA Friday.
What I've come to now call regular FMLA, right? Like the kind of FMLA that doesn't have to involve a global pandemic.
And I agree with you. The questions are coming in on regular FMLA, frankly, on all sorts of things that are not pandemic related. Now people are getting back at it, have the bandwidth, right, to think these things through and not fly by the seat of their pants anymore, right?
Right. Yeah, and just anecdotally, a lot of questions. I'll just say this. I've been doing a lot of FMLA work for a long time. You know that. Yes. I have certainly noticed a pattern of an increase in FMLA questions and concerns when we have a competitive job market.
Oh, why is that?
When we have people being who are employed, right? Those who are employed, who are being required to work more and work overtime and work weekends, right? Because businesses can't get the number of people in the door that they need to really staff departments, production lines, restaurants, stores, etc. That pressure often results in FMLA leave and FMLA concerns.
That is really interesting. And we didn't plan this, but that's going to lead to my first question.
Okay.
You did not know that was going to lead to my first question. Because we've got some more general questions, some more particular. These are all questions actually asked by clients and all asked more than once, right?
Okay.
That's how we I kind of picked them.
So let me be clear. This episode is all going to be just you asking me FMLA questions. Is this how this is going to work?
Yes.
Okay.
Is that okay with you?
Sure. It's my
kind of
one
like
of my
life.
favorite things to do.
It's kind of like an average day in our lives, Sarah.
Excellent.
Okay. So can FMLA apply to an employee just as it relates to working overtime?
Sure. Right. Excellent question. And the answer to that is yes, it absolutely can. The FMLA regulations say if it's mandated overtime, right? If you are requiring an employee to work overtime.
Mandated, that's an important word here.
Yes, it's mandated, right? Yep. Not voluntary. Not something an employee just raised their hand for and said, sure, I'd be happy to come in, and then it turns out they can't come in on Saturday. If it's mandated, then yes, that becomes an FMLA issue, and employees can use FMLA leave if they are unable to work overtime, okay? That's not the answer most businesses want to hear. So I just got to say that out
surprising.
loud.
I think that's surprising.
It's surprising.
I think if we could live poll right now, HR professionals, say when an employee refuses overtime, does your mind go to FMLA?
For a health-related issue,
right.
Let's be clear.
Oh, yes.
Right. If an employee says, I can't work overtime because I have a migraine headache or I have some other health issue, should that trigger an FMLA concern, then the answer is yes.
I bet for a lot of folks it's no. And let's go one step further, just because I like to scare HR professionals. How many HR professionals listening think that their supervisors know that's a flag for FMLA when they ask someone to work overtime and the person says no and it's related to a health
potential health issue that could fall under the FMLA.
Do they think of contacting HR?
Right, sure, and that's a training issue. Really, in the context of overtime, though, what I see most frequently and what's happening right now is less of that and more employees coming in with a doctor's note that says, I can't work more than 40 hours a week.
Yep.
That's usually how it comes up. It's not in the moment of, I can't work overtime or I'm refusing to because I'm not feeling well. It's the note saying Sarah can't work more than 40 hours a week. And it does come as a surprise to many employers when I say to them, well, we need to be thinking about this first under the FMLA.
And that's an intermittent FMLA issue at that point, right? Is that how employers should be
intermittent, or it could be on a reduced work schedule, depending on how that employee's schedule, depending on that particular employee's regular schedule. So if we're talking about an employee that has a regular schedule of 50 hours a week, right? Yes. They work 10 hours 5 days a week, or maybe they work Saturdays on a regular basis, then that's what I would call a reduced work schedule FMLA leave.
That's
on the other hand, if instead we're talking about mandated overtime that varies from day to day or weekend to weekend, then it's an intermittent FMLA.
That's a great point, and that brings us full circle to your first point as to why the tight labor market right now is causing these requests. Yes. So someone that wasn't hired in for a 50-hour work week, for instance, is now being asked to work a 50-hour work week on a regular basis.
Right. So I do think it's important for HR folks to realize that is an FMLA concern. I'm not going to get too into the weeds of it because then it becomes very complicated about how you calculate their FMLA entitlement and how that all works. I'll just say one last thing, and that's sometimes those situations are a good opportunity perhaps for a second opinion, particularly when you start then getting requests like I'm actually seeing that are along the lines of Sarah can only work 40 hours a week and they have to be Monday through Friday. Right? Because
you've seen that.
Oh, yes. Yes, frequently. I see that frequently, right? And so just a reminder to our audience that any use of FMLA leave, the employer has an obligation to provide information demonstrating that legitimate medical need, right? And so when you get a note like that, there is an opportunity to clarify that with the doctor and say, well, help me understand why for this particular condition it matters.
Right.
which days of the week they are.
Right.
Right. And out of the box, it's usually hard to imagine why it matters whether it's a Tuesday or a Sunday.
Right.
Okay.
Interesting. Okay, so let's start with a more general question.
Okay,
so not one that will surprise a lot of people, but we still get questions on it, right?
A softball question? Like an easy FMLA
Well,
question? Or is that an oxymoron, maybe?
To be fair, because I feel in this situation I'm more in the boat of the listeners. Easy for you.
Okay,
so easy for you, not easy for lots of folks. Particularly, frankly, folks that might be newer to HR, right? They don't teach a lot about the FMLA, right? When folks, sometimes before they get hired into HR, and it's very tricky.
Sure, they're just thrown into the fire, right?
Yeah, exactly.
Yeah, absolutely.
So what about employers with no-fault attendance policies, and an employee has either a leave or time off as intermittent FMLA, because that's the part that tends to trick people up in this area, right? Can those absences be counted against them under the no-fault attendance policy?
Right. Great question, and such an important question, really.
It's foundational, really, to a lot of what
and
we
I'll
do.
explain why in a minute, right? So to your point, when we talk about intermittent FMLA, of course, what we mean is employees can be approved to use parts of their FMLA entitlement, and they can use it on sort of an unplanned, unscheduled basis, right? So if they have a chronic health condition that flares up, right, they have a certain number of days or hours per leave year that equal 12 weeks, and they can call into work unplanned due to a flare-up like that, okay? And so for an employer that has an no-fault attendance policy, usually what that would mean for that unplanned absence is they would get an occurrence under the under the no-fault attendance policy. That's the whole point, an occurrence, right?
Yes.
And so if that call-in is for an FMLA qualifying reason, okay, and this is important, they cannot count that as an occurrence under the attendance policy. The FMLA would consider that to be interference with that employee's FMLA rights, and that's unlawful.
Okay, so here's the follow-up question that I know I get, and I'm sure you do. Well, how do I know?
Yeah.
How do I know when an absence is FMLA related or not? So how do I know whether I can count it as an occurrence or not?
Right. And questions like that explain why lawyers like me spend a career talking about the FMLA.
Yes, it sounds very easy, what you just said.
Right.
But then a supervisor just gets a text that says, I'm not going to be able to come in today.
Right. And the answer is a little different depending on whether that employee has already been approved to take FMLA or not. Okay, so let's take the easy one first. Let's just assume for a minute that I have a chronic serious health condition, okay, and I have been approved to take intermittent FMLA for that condition. My employer's already gone through that process, right? And I've been given the designation notice, and I know I can take it. In that case, I can be required, right, when I call in, to say that's why I'm missing work, and that is my obligation. Okay, I have to either say FMLA or I have to mention that health condition specifically.
So if I have required my employee to do that in their designation letter, in our FMLA policy, maybe in talking to them, right, when they came to meet with HR about this in the first place, and let's just say they leave a message, and their message does not include FMLA or the health reason that they're designated for how they got approved for FMLA, then I don't have the obligation to follow up with them to ask.
Correct. You do not have that obligation. Now, the one thing I will add as sort of an extra credit recommendation is to anticipate that maybe down the road that employee is going to dispute their discharge or discipline for attendance violations. And they are going to say, no, actually, when I called in on July 16th, I did say FMLA. Okay? How are you, employer, going to be confident that they didn't?
Yep.
Okay? And so think that through. I highly recommend that employers have some sort of documentation process in place. If it's a call-in line, you're recording it in some way. If somebody else is taking the phone call, they are recording, they are writing down exactly what was said. And it's all over the place depending on the size and the type of employer, but some employers have policies that say if you're calling in for an approved FMLA reason, you have to also directly contact this person in HR. Right? And some say you have to do it via email to this email address. So then that documentation is in place. Okay. But just file that away, because when we start sorting out FMLA disputes, we do often get into issues and concerns about what exactly was said during a call-in for exactly that reason.
Yes.
Okay.
Yep.
Okay. So that was the easiest example. I'm already approved.
Right.
If I haven't been approved yet, right? This is a brand new thing, right?
Yep.
I start calling in.
Calling on a Monday. Let's just make it real specific.
And I'm indicating that I'm missing work for a reason that might fall under the FMLA. That might be a serious health condition. And we can take the example that's used over and over again. Let's just use migraine headaches. Right?
That's exactly what I was about to ask you.
That's
that was
the example that we always use when we talk about FMLA. I don't know why. It just seems like an easy example. In that case, the standard is different. If I haven't been approved yet, I only have to give my employer enough information to put them on notice that I might be missing work for something that falls under the FMLA. And then my employer's obligation is to recognize that and start that FMLA paperwork process, right?
What if they say, which often happens, I'm not feeling well?
That is
on
not
Monday.
enough, right?
And then on Tuesday, there's another message. I'm still not feeling well. I won't be in. And then on Wednesday, there's one more message, never mentioning a specific condition, right? When does it get to the point where it triggers that obligation?
Yeah. Well, there's lots of different serious health conditions under the FMLA.
Yeah.
Okay. And so in that example, what I would say is if they've called in for more than 3 days and it's for their own health condition, okay, I would encourage that employer to ask some follow-up questions about whether they've seen a healthcare provider or whether they've been prescribed medication. Okay.
So we should follow up even if they don't mention a specific condition in their message.
Yeah. Usually, though, where I see problems arise is not in the repeated absences for the same condition, but the intermittent, I'm not coming, I can't make it in today because this is going on. And it won't surprise probably a lot of HR folks to hear me say this. There's often a problematic gap in information between what the supervisor is hearing in those call-ins and letting HR know what's going on, right?
Yes.
So, and to be clear, the supervisor is part of that employer. So when I said the employee has to give the employer enough information to recognize this could be an FMLA issue.
Yeah.
Okay, that includes the supervisor.
So that's a great point. I think that's a huge risk factor for many organizations, and there's room for opportunity there. So I'm going to pause for a quick PSA, because we do trainings on that, right? Supervisor trainings. HR gets tons of training on FMLA, and supervisors sometimes get very little or nothing. And sometimes they've just, even if they had it, some supervisors had it, some supervisors may have been recently promoted, right, from a non-supervisory position. So this is an area where if you want to start reducing risk for your organization, training supervisors, frontline folks presents a lot of opportunity for you.
And I've gotten a lot of requests recently on, do a high-level FMLA training for my supervisors so that they understand this issue. And while you're at it, let's do a high-level ADA reasonable accommodation training for them too. And that's fantastic. You do that in 45 minutes or an hour.
Yep, the health issues in the workplace, right? When your employee has a health issue, et cetera. And it is high level. They don't need to worry about the certification forms, right? And the timing of all that. What supervisors need to know is, what are the triggers?
Yep.
What are the triggers? When do I call HR, right? Who are the experts in managing the details?
Absolutely. Well worth the time.
Yes, I agree. Okay. Can I ask you about another one that really makes my head hurt? And I know it makes a lot of our clients' head hurt.
Right, too. Exactly, right. Warning to the audience, this might make your head hurt.
Okay, deep breath. When employees have health issues, right? An employee comes to their supervisor, to our last point, or to HR and explains what the health issue is. But it usually doesn't implicate just one law or another, right? They have an issue that can touch on a whole slew of areas. So let me ask you first about workers' comp. How does the FMLA interplay with workers' comp? And by the way, this is not a workers' comp podcast. So we're not.
That's a great idea.
That is a great idea. Let's sock that away. And I know who we could call as an expert on that.
Absolutely.
But for now, let's just assume whatever the health issue is qualifies, right, as a workers' comp.
It was work-related, so it happened.
We're not going to get into the weeds on whether it actually did it. We're just going to assume it's been through the workers' comp process. It's been approved. It's been deemed by the workers' comp gods as being work-related. How do those two things interplay?
Yeah, right. It's actually not, that piece is not as complicated probably as many folks might think. Think of workers' comp as pay, right? As compensation.
Wait. Workers' compensation is compensation?
Is compensation. That's exactly right.
It sounds so obvious.
And by that I mean a workers' compensation insurance policy covers medical care and costs, right, for a work-related injury. And then if that employee needs to be off work, it pays them
it's all
to
about
a
the
certain
money.
Maximum, right, for their time off work. Okay.
Got it. Money.
FMLA actually is about leave. That's the L in FMLA, right? And FMLA is actually not about pay at all, right? So the workers' comp piece deals with how much they get paid for being off work, and the FMLA then deals with the leave itself and how long they are able to be off work and whether you have to hold their job for them. Okay?
Got it.
Both of those should be running concurrently.
Okay.
Now, sometimes when we have an employee that's had a work-related issue, employers are so excited that the workers' comp flag goes off in their head and they know what to do about it and they follow the workers' comp process and they're doing a wonderful job and they completely forget about the FMLA.
Right. They think about these things as separate buckets of types of leave, maybe.
Yeah.
Which is not true at all.
And it happens all the time.
Yep.
So if folks in our audience have done that, no, you are not alone. That is a frequent occurrence, okay?
Yes.
So try to remember when you have an employee who has a work-related injury and is off work, right, which isn't always the case. Sometimes they're not off work. But if they are off work, you also really need to be following the FMLA process, okay? If you don't, okay, the problem is that all of their time off work you've probably protected because it's what HR folks I've heard call a workers' comp leave, right?
Yeah.
Which doesn't really exist because I mentioned workers' comp is about compensation, not leave. But they haven't burned any of their FMLA time.
Right.
Right? So I get calls saying this person has been on a workers' comp leave since last October. What can and should I do? And I say, well, have you designated this under the FMLA? And they say no. And I have to give them the bad news that they actually have 12 weeks of FMLA still to take.
12 more.
There are options for retroactively designating it that we can address on a case-by-case basis, right? Okay. But the better course of action, right, is out of the gate to understand, designate it as FMLA.
Perfect. Okay, let's switch now from workers' comp to another health-related statute that interplays sometimes, the ADA, Americans with Disabilities Act. Right. And this one has a closer relationship.
It does.
With the FMLA, because I know you've had more than I have, but I've had so many conversations about, okay, they're entitled to 12 weeks of leave, the 12 weeks is up, and they can't come back. Right. So that means we're good ending the employment, right?
Yes. Yeah.
And we have to say, not so fast. Not so fast. And people respond, wait, I thought it was only 12 weeks maximum. And it's a little more complicated than that, right?
It is. It sure is. And the FMLA, the interplay between the FMLA and ADA is much more complicated and nuanced than workers' comp. So you were right in asking the easy question first, right? So let's take first that continuous leave question, right? And the short answer is you're exactly right. Under the ADA, time off work, a leave of absence can be a reasonable accommodation under the ADA.
Yep.
So when you have an employee that's exhausted their 12 weeks of FMLA leave, still can't return, what that means is you need to, at a minimum, have some sort of process in place so you're doing that interactive, reasonable accommodation due diligence, right? We know what that means, okay? And we've helped lots of employers develop a process in place that helps you do that. The good news is continuous leave under the ADA, okay, does actually take into consideration the business, right? The business needs, right? And whether it would be an undue hardship to continue to provide the time off work. As probably our listeners know, the FMLA doesn't care a bit about your business operations or hardship or anything else, right? And so, but also beyond, when we think of other types of FMLA leave, the ADA also comes in and out of that too.
Should we use the intermittent leave for migraine headaches example?
Do you know what example I want to use first actually is the overtime example?
Oh, because back to that.
Yeah. In the last few weeks, I actually have gotten lots and lots of phone calls on exactly that, right?
Okay.
These overtime. Right. So employee brings in a note saying, I'm really essentially saying, it's July and I live in Michigan and I haven't had a day off, right, in 17 weeks. Here's a doctor's note saying I can only work 40 hours a week, okay? When I say to clients, you need to think about this under the FMLA, okay? Yeah. They ask what I think is a fabulous question, a great question, and I love it. They ask me, well, can I just think about it under the ADA and say they can't perform their essential job functions then?
Yes.
Right?
I think, by the way, when we were talking about FMLA at the beginning of this, regarding that exact example, most people do automatically flip to the ADA, right?
Yes.
That's why they're not thinking about the FMLA.
Yes.
But they are thinking about it under the ADA and then just forget the FMLA. It's not that they ignore these requests, right?
Right. And my answer is, thank you for remembering the ADA, because it needs to be remembered for sure, and sometimes doesn't get remembered often enough, okay? But in that case, unfortunately, we do have to think first about the FMLA, and we can't say to an employee, we're going to deny your right to take FMLA leave and instead consider this under the ADA and then decide it's an undue hardship, right, to allow you to work this schedule, and therefore we're going to deny it, right? So in that case, the FMLA analysis comes first before the ADA, okay?
Got it.
However, whenever we're talking about intermittent or reduced schedule FMLA leave, okay, there is often an opportunity to have the conversation with the employee about workplace accommodations. Is there anything we could do in the workplace or with regard to your job so that you could work more than 40 hours a week, so that you didn't need to take intermittent FMLA leave, for example?
So an employee can suggest, just to get into the ADA a little bit, I know this is not ADA Friday, it's FMLA Friday.
Well, it's hard to talk about FMLA and not ADA.
It is. Health issues almost always overlap. It's hard to imagine, frankly, many health issues that don't. The employee may need a reasonable accommodation that may be established, but an employee doesn't necessarily get to choose which accommodation, right? They can certainly suggest an accommodation that would work for them, but an employer's always on solid ground, exploring creatively during this reasonable accommodation process, if there are other opportunities to make this work out.
Yeah, and to be more clear, employers are open to explore opportunities even if an employee doesn't ask for a reasonable accommodation. Okay, let's take an example. I request intermittent FMLA leave because I have migraine headaches. Okay, my employer understands that I have a right to take intermittent leave under the FMLA if that's what I need from a medical standpoint, right? And they can't deny it. But there'd be nothing wrong with my employer saying, you know, you've got a right to take this time under the FMLA, but we'd also like to talk to you about whether there's something we could change with regard to your jobs to reduce the number of migraine headaches you have. And maybe I say to you, well, actually, the lighting in my office is terrible. It's fluorescent lighting. And if you gave me different lighting, or I work on the production line, and if I had a break every 4 hours, right?
Yep.
I would have fewer migraine headaches.
Yep.
Right? We can address those issues, right? And I've seen that actually work more often than you might realize as a tool to help address concerns about intermittent and reduced schedule FMLA leave.
Because sometimes employees don't want to burn through their FMLA, right?
Yeah.
Every employee is different,
Yeah.
and their needs are different, and what they see coming up in their lives is different, right? So some employees may welcome that opportunity. Yeah. Okay, so I think we have time for only one more. I know. All right. I know our list was a lot longer.
Let's make it a good one. Well, maybe we could have a regular FMLA Friday question episode, and we can just keep gathering the questions and going through our list.
I think we could get through a lot of Fridays doing
I think
that.
so too.
Right. Okay, so just one more, because it connects with something you said earlier.
Yep.
What if a request for FMLA significantly disrupts a business operation? Right? I know you get those calls. Sarah, I've been to your workshops. I know the rules, this, that, but we are in a bind here.
Yeah.
Is there anything an employer can do in that situation?
Well, let me just say, that's almost all of the FMLA calls I get. That's why they're calling the lawyer, right?
Right. Yes.
Yeah, so absolutely, right? And when we say disrupt operations, it's usually in the context of intermittent FMLA, right?
Sometimes.
This employee needs this leave, and it is their job to open the offices for our patients. And we cannot have a situation in which he or she might call in unplanned.
Right.
At any time.
I've seen it happen too when there's a small department, maybe 4 or 5 people responsible for a certain function of the business working, and maybe 3 are already out on a leave, right? So it comes up in situations like that too, when there's a large group, right? All kind of concentrated in one area.
Yes, right.
Is that ever an argument under the FMLA?
It is not.
Yeah. I know how I talk to clients.
It is not.
How I explain it. How do you explain?
Well,
the
usually
clients are obligation.
I mean, I will say this: there's a legal answer, and which we get through very quickly.
Right. That was not hard for you.
And then we spend a lot of time. Talking through more practical options and advice, right? And those are very client specific.
Right.
Okay. So I don't want to send the message to our listeners that the door is completely closed to finding some sort of solution to a problem like that, right? Because we often can help through that. But from a legal standpoint, unfortunately, the way the Department of Labor wrote the FMLA regulations only confirms to us that not a single one of them ever worked in HR, right?
That's not the only indication. It's just one.
That's a good point. Because they leave really very few options for employers who have individuals for whom it is very, very difficult and a huge disruption to the business to allow that person to take 12 weeks of unplanned intermittent leave per leave year, right? Number one, unless we can demonstrate that person is a key employee, which is a very difficult burden and has to do with compensation and not job responsibility.
I noticed you didn't mention that when you gave a quick note, because you don't want people to over-rely on that.
It's very, very hard. And again, it relates to compensation. It doesn't even speak to the business operations or what they do for their job. So there's no easy out. The rules about allowing them to transfer to an alternative position only allow it if they're taking intermittent FMLA leave for planned medical appointments, meaning we could have backup in place. It makes no sense, right? It's the opposite of that causes the concern for which most businesses would want to pursue transferring that employee. And so it really does tie employers' hands from a legal standpoint, and the conversation then usually turns to, okay, this is a problem we have, and how are we going to find the best solution to it? Some of it involves creative staffing, some of it involves conversations with the employee, et cetera. It all depends on the circumstances.
The way I think about it, sometimes in moments of frustration, is it was an intentional policy by Congress and the President back when this was first passed. The reality is, I don't know if it's the reality, the information they presented was that when employees have to leave employment for a health-related reason, it's often very difficult to re-enter the employment market. And that puts a burden on society, right? Sometimes people then, they lose their health care insurance, sometimes they need food stamps, then the children also, right, suffer in school, et cetera, et cetera, et cetera, right? To all sorts of society, it's like a ripple effect, right? The stone in the pond. So they were trying to shift, right, some of the pain that we all feel when a wage earner has a health issue. There's going to be some impact here, and they're trying to shift it more onto the business community, right? So that it's not all absorbed by these other entities. So we can agree with that or not.
Right.
But I do sometimes think it's helpful to understand that this was not an accident, right? Why aren't there more outs for
Although I will
businesses?
say, I'm not sure the Department of Labor thought through exactly the impact of intermittent FMLA leave and how that can be used by employees in the amount they can take, right? So
I agree with that.
Anyway.
Yes, I think when we heard the debate about FMLA and when it was adopted, really most people were thinking about it as continuous leave, right? Wasn't that
12
all the
weeks
conversation?
Of leave, and employees should be allowed to take continuous leave and then be able to re-enter the workplace.
Right.
That concept, I think we are at a point in which that's largely uncontroversial. Right. As I mentioned, I get very few phone calls about that, right? Very few. It's the intermittent leave that directly impacts the business, impacts coworkers, that really causes concerns for employers. So I feel like we're leaving on a low note.
Well, what can we do to cheer people up on a Friday? Is FMLA Friday ever going to be a high note?
Yeah, well, that's a good point. FMLA Solutions Friday, right? Excellent.
The good news is, okay, I'll leave it on a high note.
Okay.
So the FMLA, as you know, is part of another four-letter word that starts with F, which is the FLSA.
Yeah, right.
It's actually a section of that. And as you know, I love that, right?
Right.
And one of the great parts about the FLSA and the FMLA is that there are rules. We may not like that there's all these balancing tests and what is reasonable and what is undue hardship. That maybe create some difficult situations for clients, but on the bright side,
it makes it predictable.
There are rules.
Yes.
There are forms that the government has provided us.
That is a good point.
There are guideposts, and we may not like the guideposts, but at least they're there. Yeah. And that can be comforting.
Okay.
Right?
We will go with that. And
I like that.
And
okay.
I just want to say, I love that FLSA is your thing and FMLA is my thing. It's like a yin-yang thing we have going on here, right? So. All right. Indeed. Well, with that, have a great weekend, Rebecca.
Yes, you too, Sarah. See you next week.
See you soon.
Bye.